Okay, this is where it starts to get fun. We are trying to understand the rules and regulations of each state. Why is this important? Because if you don't know, you're going to be taken for a ride with the agent, or worse, well, maybe not worse, but they're not going to take you seriously because you don't really know the lay of the land for their state. So if you go ahead and, say, hey, can you send me the Form 1 while you're in WA, they're not going to know what you're talking about. So it is important to get crystal clear on what are the legal terms, how do they work, and what is the difference between each state. The beauty is, guys, is you have access to this amazing cheat sheet. So a lot of the information that I'm going to be covering off in this session, you really only need to hear once, but this cheat sheet, print it on your fridge, print it on your computer, you're going to use it all the time. It's so super helpful to be able to say, oh, great, yeah, that's right. There's no cooling off period in WA, so I just need to be a little bit more careful. What does that look like? All of that kind of stuff. So one thing to mention is I'm not a lawyer. Never have been. Never will be. I was never a solicitor. I never will be a solicitor. But after going through hundreds of property contracts and hundreds of property deals, I've learned one thing, that you need to lean on your experts, but you have to know your stuff, right? You can't just walk into these things blindly because you will get in trouble. I've seen it before where someone said, hey, Mr. Conveyancer or Mrs. Conveyancer, can I sign this document? I said, yeah, you can sign it. Not realizing that the pest and building clause was a structural clause that didn't allow them to get out of the contract. So the good thing is property law in Australia is highly regulated, and for the most part, it follows a pretty standard structure. So that means you don't actually need a law degree to navigate it and understand it, but you do need to have a bit of an idea of, that's the point of this session, right? Just understand the basics. And those basics can change depending on the state you're in. And when it comes to property investing, knowing the legal stuff, it's not a nice to have. It's an essential. It protects you. It protects your interests. It keeps the deal moving forward. It lets the agent know that you're smart and you know the game, how it works. And also it stops you from making costly mistakes. So whether you're just starting out, you have a couple of deals under your belt, getting a handle on the contracts, the disclosures, the rules for each state can mean the difference between a super easy transaction or fumbling the deal of a lifetime. So in this section, we're going to break down exactly that. We're going to cover off the fundamentals, the contracts of sale, the vendor statements, the more trickier bits like covenants, caveats, and easements at the end, and also the top 10 power clauses that you should have in your contracts, along with some red flags to watch out for. So this is a bit of an action-packed session, so I'm going to just dive straight in. So you're not going to be a legal expert after this, but you will have a far solid, better idea of how property contracts works. So you can have far better conversations with your experts. So the whole point of all of this is to give you confidence and control over your property contracts. So the rule book. The absolute rule book of your property purchase is the contract of sale. So the contract of sale is a legal document that defines all of the terms of the property transaction. So this has the names of the parties, right? You've got to ensure your name is correct. So typos can cause a massive issue down the line, and it depends on which state as well. So Queensland, for instance, you can't get the name wrong, otherwise you have to crash the contract and restart one all over again, which is a bloody nightmare. In South Australia, it's a little bit more lenient. You can just do a deed of you can just change the name and do it that way. If you're buying through a company, a trust, or a structure like that, double, triple, quadruple check the names on those contracts, because again, 98% of the time, the agent doesn't know what the correct name needs to be, but your conveyancer or solicitor should. But double check, hey, by the way, have you done a property contract for a trust and company in this state? And just ask the question, because you just don't want to be drawing up a whole new contract, because that may give the vendor an ability to pull out of a deal. So property details, that's going to be on the contract of sales as well. So you need to make sure that the full address is there, the title reference, the land description, check all of those details match. Another important thing is the land size. So a perfect example of this is we were buying a property that had a land size of 700 square meters. However, we were chatting with the agent, and the agent was only selling 500 square meters because the vendor had promised his neighbor 200 square meters because simply he didn't want to mow it anymore. So he said, mate, that's your land, you have it. That person died, and the neighbor's now saying, hey, where's my land? This is my land. There's nothing formally in writing. So we actually were going for that property as a purchase, and it just became a massive problem, right? According to the title and the contract, we were getting that 700 meters of square land, but digging deeper and doing more due diligence, the neighbor had it in writing that he was giving him 200 square meters of land. So that created a really complicated legal situation and ultimately made us pull out of the deal, because legally speaking, he may have had some right to it, and it becomes a big nightmare. So double check the land size and just make sure. I mean, that's a super rare case, but the other one, purchase price and deposits. The contract must state the total purchase price and the deposit structures. Agents are humans too. Sometimes they make mistakes around the numbers, so always double check that. I've actually seen contracts where we're like, great, we'll take this for $550,000, and they put on $650,000. Now, I don't feel like he did it deliberately, but it was on the contract, and we're like, whoa. And he's like, oh no, that was another deal that I was working. So always double check. Deposits are a funny one, right? So that's on the contract as well. So everyone's like, oh, I need to put down a 5 or 10% deposit. I've bought a property with $100 deposit down. So you can do whatever you want. Like what you can do, like in Victoria, for instance, there's like a small upfront deposit, which is $1,000, which is payable when you sign the contract. So you sign the contract, you pay the $1,000, and then the remaining is due on unconditional exchange of contracts, which may be that 5%. What I like to do is just whatever covers the agent's commission. That's all it needs to be, really. Like, it can be less, but really, if anything goes south on the deal, you just want to make sure that the agent's covered so he's comfortable or she is comfortable with that. So I usually have a $15,000 deposit or a $17,000, $20,000 deposit, and that covers me. So you don't need a 5-10% deposit. Like, if you're buying a $700,000 property and you're having a 10% deposit, that's $70,000. So the standard rates kind of vary state by state, but really it's an agent by agent thing. What I'm finding is in Victoria, they ask for a little bit more, but yeah, it's just a negotiation point. Just say, look, I'm an investor, right? I don't want to put $80,000 in your trust account because I'm not going to get any offset against that. We're just wasting money. We're investors. We care about our cash flow and we care about our money. We're going to go through this deal anyway, and you've got $20,000, so chill out. The other point to mention on deposits is the deposit is stored in the agent's trust account, right? So it's not really at risk. There are huge rules and regulations around trust accounts for agents. So just know like, oh, it's going into the agent's trust account, I can't trust them. No, they've got all the rules and regulations around it. So if you pull out of the deal, they do have the right, if it's under cooling off, to take the 0.25%. But we're going to be covering the cooling off periods a little bit later. On that contract to sale, we have settlement terms. We have standard is based on the state. So I mean, we've got our cheat sheet here, so we can kind of go through that together. But if we have a look at settlement, standard settlement time frame, can you guys see? No, it's not doing it. Oh, there you go. Vendor statement, standard deposit. So New South Wales is 42 days, 30 days for Queensland typically. WA is 30 to 90, 30 to 90 for South Australia. Victoria is 30. Tasmania is 4 to 6 weeks, 30 to 60. So I guess it's just using this type of language when you're on the phone to real estate agents saying, yeah, 4 to 6 weeks is fine if you're based in Tasmania. The other thing to mention is it's all negotiable. So one of our questions in the Agent Call Masterclass is, great, what's the vendor looking for? Are they looking for a super, like a long settlement, like a 60-day settlement? Later on, I'll show you a really creative contract that we put together to see, to show you the difference of what you can do. One thing on the settlement side of things, don't get too excited and say, oh, I'll give you a 10-day settlement if you've got finance included. There are pretty big penalties, and we've got it listed here, right? You can see the states that have penalties for settlement. Some of the biggest penalties are in Victoria. Also, a lot of what I'm seeing recently is agents are putting in the contracts an ability to charge even more if settlement is extended. So just be aware of that. Okay. So what else do you see on a property contract? Inclusions and exclusions. So what stays with the property? Does the fixtures, does the appliances, does the furniture? This is especially relevant for properties that are furnished. Like you can negotiate these things. Some of the time you get a dishwashers, other times you don't. So you've got to know what's in there, and that will be listed there. So are the window coverings included? So I've seen people incredibly upset when they have this amazing property with all these beautiful blinds, and then they get to pre-settlement inspection like, where are my blinds? Well, they're not included. So that's a fixture that was not included on the contract. However, if they are included on the contract, you then have to push back and say, guys, you have to put the blinds up because that was in our inclusions. Standard conditions, are going to talk to more advanced conditions later down the track on this session. Standard conditions are finance clause, pest and building clause. These are some of the more standard ones that you should expect. The beauty of the contract is everything is negotiable, right? You can structure it pretty much however you want as long as you're staying, within the legal boundaries. At its core, a property transaction is just a transaction between two parties, okay? It's just two people saying, you know what? I like this property. I want to buy it. Well, I want to sell it. Well, can you sell it with the dishwasher? Can you allow me a long settlement? Can you do this? The best way to structure a deal is something that is giving the vendor what they want. So it doesn't always have to be the best price to be the best deal. The right terms can really far outweigh for you. You can really get far better terms that save you tens of thousands of dollars if done correctly. We have our cheat sheet, but what does all this stuff mean on here? And we've kind of alluded to a lot of it already. I just want to make sure that we 100% cover it off and you understand the rules of each state. As I said, everything in Australia is pretty standardized, so you're not going to get too caught out. So cooling off period. So a cooling off period allows you to pull out of the contract for whatever reasons. That change your mind. I don't want to do it anymore. The problem is when you cool off, there is a penalty associated with that. So just be careful and know that you're going to have to pay a fee for it. So the thing to mention as well, there's no cooling off periods typically when you go to auction, and there are ways to waive your rights. Okay, so there is waiving your rights as well. Deposit terms, that's pretty straightforward. 5%, 10%, you can have it whatever you want. I like to go with that kind of 15 to 20 grand. It shows the agent you're serious. And then the other thing is vendor statements. So what a vendor statement is, it kind of gives you a bit of an understanding of the vendor's obligation and the buyer's rights. So when investing in property, understanding the legal obligations for that specific area gives you a whole lot more understanding of, oh, great, here's where the opportunity is. So in Victoria, it's called the Section 32. In South Australia, it's called the Form 1. But essentially, the key components, each state has different rules around what they have to show you in that. So this is just standardized. This is these components that I'm going to cover off now. It's completely different state by state. But essentially, it's a legal document that discloses the essential, the essential information that you need to know for that particular area. So title details, zoning information, rates and outgoings, encumbrances and restrictions, building approvals and notices, utilities and services, if there's any easements on the property, if there's any encumbrances on the property. Another one is in Queensland, right? The new rules have come up where they have to tell you when the rent was last raised on the property. So that's something. So failure to disclose these key details could render the contract void. So you see something wrong with the contract, you may be actually able to pull out of that deal, okay? So we're going to run state by state, and I'm going to run the least buyer-friendly areas, and the winner is Northern Territory. They are the least buyer-friendly property market there is. So in terms of what they have to tell you is a building status report, a title search from Land Titles Office, and then any known land contamination or illicit drugs or anything. Minimal disclosures required in Northern Territory. This is making them the number one winner. You've got to carry all of the burden if there is one. There's little to no a regulation around it. Tasmania, they operate on a thing called caveat emptor. You may have seen that before. It's a Latin word. It pretty much stands for buyer beware. So they have a voluntary vendor disclosure statement that is not legally required. So, no, we're not going to give you one. So they understand that. So it very heavily favors the seller. They don't really have to give you too much whatsoever. WA, they get a little bit better. So number 3 on the list is WA. There's no cooling off periods, but their vendor statement, it has very minimal information. If it is on a strata plan, they need to give you the bylaws and all of that information, but very similar to Tasmania and WA. Minimal disclosures, not much going on. Victoria, Queensland's the next one. The seller disclosures obligations are now generally integrated into the contract themselves. So they don't actually have like something called the Form 1 or the vendor statement. It's all built in. So this has registered land encumbrances, unregistered lease, the tenancy agreement if there is one, pool safety compliance, information about the smoke alarms, but actually that doesn't have to be in the vendor statement, but you do want to double check the smoke alarms in that situation. So less demanding, favoring sellers still, but buyers get a little bit more information. Then it goes to South Australia. That is the Form 1. So that has like title restrictions on the property. It gives you the easements, the encumbrances, any services that are connected to the property, rates, taxes, notices, orders, zoning information. It gives you it's kind of a fair and balanced market. I really do like the Form 1. It gives you everything that you need. It does allow you to pull out of the deal as well if you haven't been served it within 2 days of the cooling off period, which is awesome as well. New South Wales is actually quite buyer focused. So where's New South Wales? Let's go to here. Rather than having a standalone vendor statement like in Victoria that we'll get to, they just require the seller to attach certain prescribed documents. So that's zoning certificate, sewerage diagram, property certificate, strata and community plan documents if there is. And yeah, title search plan, yep, all there for you to see. There is the right to waive your cooling off with a 66W, which then means that you can't have your 5-day cooling off period. Another thing just to be wary as we discussed. Victoria, this is Victoria. They have something called the Section 32, and it must be provided before you can actually sign the agreement. So right now we're looking to purchase a property, but they haven't got the Section 32 document. In South Australia, you can sign the agreement, the contract by the agent, before that disclosure document comes. In Victoria, you can't sign that. So that comes through the details of the mortgage, the debts, title restrictions, building permits, owner-builder warranties. It's a lot more information. A well-detailed, well-structured document. It's pretty big as well. And then we've got ACT. They are the most buyer friendly, probably because the government makes all the rules and they want their properties the most done. So energy efficiency rating statement, building and compliance inspection, asbestos advice and assessment report if required, pest and building report, lease conveyance inquiry documents, owner corporation details. That is how it works. So the best markets, the worst markets to buy from contractually are the ones with no cooling off. Typically, that's the struggle. I love South Australia by far. For me, is the easiest to pull out because of that cooling off period. Another thing that you'll see in contracts is pre-approval, conditional approval, and unconditional approval. So just to highlight some of those things, a pre-approval, sometimes called an in-principle approval, only assesses the buyer's finances and not the property itself. It gives like a broad, high level, this person can go out there and borrow $500,000 at a 5% yield. Conditional approval goes that extra step, such as evaluation on the actual property, and starts to link the property and the person together. An unconditional formal approval means the lenders fully assess both the buyer and the property, and the loan is fully approved and ready to go. Now, don't get me wrong. You read that fine print, the bank can pull out at any point in time if they decide to. And it sucks. Contract days. So you think you're just counting days, right? You think it would be straightforward. It's all going to make sense. It's not. It's really not. They do make it tricky. So what actually counts as a day? I bet you're saying, Joe, what do you mean what counts as a day? Well, in contract terms, a day means a normal calendar day, weekends included. This is sometimes called a clear day. So 5 clear days, right? But if the contract specifies business days, then weekends and public holidays don't count. So, for example, if the contract says the deposit is due in 5 days, that means straight days, weekends included, unless it specifically states business days. So I've seen people that have gone into breach of their contract and the buyer has pulled out because they thought they had 5 business days to pay their deposit. The vendor realized that they paid a stupid price for it and they pulled out of the contract because they broke their clause in the agreement by not paying the deposit within the 5-day period of time. So very important that you know the difference between days and business days. And the date of contract exchange doesn't count as day one. So if you exchange on a Friday and you have 5 business days to pay the deposit, it's due on Wednesday.